Thank you, and thank you very much, because I think, and I'm sure that the audience will fully agree, that this panel with the epitome of sexiness, in a way. Just to launch maybe not the debate, but one first question. Even if we talk about deluge of data or yottabytes, I discovered yottabytes today. Yeah. And going back to some of my initial questions, it seems to me that you would all agree that when it comes to antitrust or merger control, the answer about data economy doesn't lie in new tools or a revolution of tools, but slightly adapt tools that exist, and to base this adaptation on cautious analysis of case law, even if some regulators, as you said, Professor Picker, might have regrets when they think about today about the Facebook and WhatsApp decision. Just to nudge the bit, would you all agree, or would you have some comments on this idea?
I was delighted by what I saw as the consistency across the conversation. Yeah, exactly.
That's key for me in all your intervention.
I agree with that. That's not to say we can't learn things, right? And so I think that's different. But that, in the United States, we talk about the common law method. We've been learning in antitrust since we passed the Sherman Act in 1890. So, but that's a framework in which we, as you just said, sort of work with each situation and look at it and understand it. And we bring to bear the tools we've been working. Sometimes we'll screw up, but so I'm very comfortable.
Yes, please.
Yes, exactly. I think exactly the same. We do not need major new tools. Maybe some tools can be slightly adjusted, like the notification threshold, for instance, which I mentioned earlier. The possibility of interim measures should also be explored, especially sometimes the complainant does not dare either to complain or to ask for an interim measure. So sometimes it is up to the competition authority to take this responsibility, and not only to the plaintiff, because nowadays it is only the plaintiff who can ask for a preliminary measure. But apart from that, it seems to me that we do have the tools.
Yeah, I do totally agree too. I mean, we clearly have the correct framework, and the framework is flexible enough to be adapted in a way that we can tackle all the issues that we discussed, actually. So I think it will be probably a major mistake to try to innovate and try to tackle this issue without taking into account what we already know, because I think these are two complex issues to have the opportunity to innovate.
Me, just to comment. Fortunately, we do not have European champion in that field. Fortunately, we go more and more in verticality in such a business. Fortunately, we miss a bit at Europe level, and I'm not provocating, the tax and the data with all the GAFA. Let's be clear. So I'm not saying that we need to use competition automatically, as a barriers. Of course, it's very complex. But don't get me wrong, the majority of the revenue of those companies are not enough, the things that we have seen.
So I do want to...
You understand my point. The majority of the Amazon revenue is no longer, in that field. You know that.
So I do want to say I think there's a category question, and you talked about this a little bit. So is it a competition question? Is it a privacy question? Is it a sector question, right? So are these natural monopolies? And you could easily conclude that they are, and we go, well, that's not an antitrust issue, but that's not to say that law is done at all. Yeah, okay.
Okay, maybe there are already some questions in the audience.
Yeah, it's more a remark than a question, but something that you didn't address today, which is to me one future very interesting question would be how to assess the value of the data. We know that the GAFAs are working on that. They're working with people like Ernst & Young or the big four, big five, I don't know how many there are now. But this would impact probably the competition arena as well.
Someone? Anyone? The only thing I'll say on that is look, I think you're going to see, on exactly on that point, and I think the California statute that I just blew right by does some of that. I think you are going to see, in the United States at least, and maybe in California in particular, an effort to figure out ways to extract more value from these companies. And if you say, well, you might say, well, just do that through normal tax policy. But if you think normal tax policy is going to apply to everybody and you're really looking for ways to isolate these companies and tax them somehow, then a valuation of data approach might be some way of doing it. I'm in this weird position where one of my law school classmates is currently running for president, Amy Klobuchar. And she is, I think, open to that idea. So, and that will take us down a valuation approach, I think.
Thank you.
I'm sorry, I have another question for you, Professor.
Maybe over here. No?
Yeah, well, you can, of course, comment, but this is an idea you've just shared with us. You mentioned the idea that we should maybe focus on users rather than data or services. And I think, first of all, it's a very good point. Notably because, for example, in this case where Microsoft bought GitHub, I don't know if any one of you knows GitHub, but it's actually one of the biggest platform for coders in the world. It's an open data platform. And in this case, the commission had to review the transaction and cleared it absolutely without any condition on the same basis as the one used for Facebook and other cases we mentioned today. So, but why Microsoft bought GitHub? It's basically because of the number of users of this platform. It didn't buy the codes, which were basically open to everyone. So I think it's a very interesting idea. And actually, I would like to ask you, what do you mean and how we could take user better into account? Is this something we can deal with behavioral economics that we've been using several years to assess the behavior of consumers or clients in competition law? I just would like to know more about this idea you just raised.
Well, did someone else want to jump in? No? Okay, then I'll talk.
I think it was you, Professor.
Yeah,
I'm sorry.
it was. Thank you very much. So look, I think it's, I said what I said, and what I mean by that is, so I think the user's point strikes me as right. So when you ask, why did Facebook pay so much for WhatsApp, right? I think that's in the UK report says exactly this as well. I think it's a really good point. What are they seeing there? And we should, as regulators, and I gather we have a genuine regulator here now. Is that right? Okay. Okay. We should ask that question, right? What are they seeing that we're not seeing, and how do we assess that? And look, either they saw them as potential competition that they were trying to kill off, right? And we should be troubled by that. Or they saw it as a way to, maybe it's a data advantage story. That's your story, right? Maybe that. I don't know if that's necessarily a bad story, right? If I have this very valuable thing that actually lets me do advertising better, and they've clearly gone into the infrastructure business, maybe that's a good thing, not a bad thing. The other thing I want to say is the fact that you've got a lot of users doesn't mean you're necessarily going to succeed. So watch Google's abysmal social strategy over time, right? The whole Google Buzz fiasco was because of that. Google Plus, nothing. So, right, and Twitter seems to be just Twitter and nothing else. So I don't think having users is sufficient. I do think having this powerful network of users is hard to do. And when you ask me why did they want to buy WhatsApp, that was my answer, and that they were looking down the road. And we as regulators should have been as smart as they were, I think. I don't know if it's helpful or not. Maybe else there's a hand back there.
the GDPR in Europe. On an economic and more competition standpoint, I would like to know if the authorities are currently thinking of a similar principle like we have for the free circulation of goods, services, and persons for data. Your knowledge and what would you think of that? Thank you.
Well, obviously, this is a question that should be handled at a supranational level, because if only one country does it, it may not be of much use. That's the first point. The second point is that it's a difficult trade-off, really. It's a difficult trade-off. When you're thinking about data, like an essential facility, for instance, and saying, okay, Google, Facebook, give all your data and so on, you may think, but it might be less risky than for other kinds of assets. For instance, data are non-rival. So the fact that Google gives its data to a competitor, it does not prevent Google from using the same data. And also these data may be used for innovation, which may not compete with Google's products. Okay, so that's a good point. Maybe the third point is that transmitting this data is zero marginal cost. Good thing. So that's a plus side, but there's also a minus side. As you mentioned, Facebook value can be very high for consumers. And of course, if you force Facebook or any other to give its data, then Facebook is going to change its model. And it's going to change its model all the more so that it has some market power. Another point that Antoine pointed out is that data is not the end of the story. There is data and there is eyeballs. The fact that I have many consumers watching ads. So I'm going to make a bet on the fact that I'm going to make data circulate freely, but I'm not sure of the result. What if Facebook keeps its dominance? Then I'm going to have a Facebook which is more costly, and I may not have more competition anyway. So it's a very, very difficult trade-off. It needs to be tackled and carefully examined, but it's not an easy task.
Thank you very much. I guess my question is to all the panelists, I would say, and I feel like I'm mentioning the elephant in the room, which is the recent discourse on let's break up big tech companies, because I guess there's this realization that maybe the mergers that we just mentioned, Facebook, WhatsApp, Facebook, Instagram, they shouldn't have been cleared in the first place. And now there's this, trend or I don't know, hype around let's break them up. What do you think about that? I mean, I personally don't support that, but clearly there is something wrong going on, and disintegration, can this be thought of as a valid, I guess, remedy in the data economy? Thank you.
The idea being, I guess, that making competing against each other might offer me a service that is less privacy intrusive. That is.
Oh yeah, I'm not sure.
The standpoint, I
someone
guess.
else wants to jump in.
There are two different points, but just to answer first the remark which was made. One of the remedies that we're thinking about is making some ex post decision on mergers. That is, because we are in a world of uncertainty when looking at these data-related mergers, because there are so many things moving on very quickly, one solution would be indeed to maybe let the merger happen, especially if it is a small acquisition, for instance, and look at the effects in, let us say, 1 year, 2 years' time, what's happening, and then indeed take the ex post measure which is deemed necessary to reintroduce competition if competition has been reduced. It's one kind of remedy that can be sorted out. So this is one solution which is on the table. Again, I'm coming back to notification threshold. The thing with the Facebook, WhatsApp that has to be borne in mind is that actually Facebook lied twice in a way. It lied the first time, and it has been condemned for that when it said I cannot merge the two data sets. And then it lied to consumers when it said, I will not transfer your data to Facebook and will not transfer And so this also has to be taken into account. So
As a lawyer, we call that potentially a negligent misrepresentation, I think was the commission did not call it a lie.
absolutely, that's a good term. Thank you.
Sure. I'm happy to address the breakup question, but if someone else wants, no, go ahead.
Just one comment on the ex post evaluation of merger. I think, I think this is really interesting, but it's a very tricky point because I mean, it can be the case that you have a merger between two companies. You wait, and two things can happen: either it works perfectly well, or it's a disaster. Okay. And well, if you see that it works perfectly well, you will see, and so with a huge increase in market share and so on, and well, you will say, well, this merger is anti-competitive. But it's not the merger that is anti-competitive. This is the fact that the people work to make the merger and the merger entity work well. You know what I mean? So my question is, it will be very difficult to disentangle what is something that is caused simply by the merger and something that it is, exogenous to this. And I would rather prefer actually, for instance, a turnover threshold, which I think it's, I'm not a big fan of the ex ante ex post distinction, but if we do ex post merger regulation, I think it's going to be tricky. But it's probably what you are planning to do. So
you have several countries doing this kind of ex post examination. United States do it. United Kingdom do it. Sweden does it. So you have already many countries doing it. It also depends on the kind of measure that you're taking to do your ex post measurement. The issue is not so much about market share because a company that has merged may gain some market share because it is more efficient, because it provides more services, okay? Because it attracts new consumers that were just not in the market before. But there are many other metrics that we can look at. For instance, did the margin on the advertising market, how did it evolve, for instance? This is the kind of stuff that we could look at. How has the privacy evolved? Even though I have to mention that there is a really tricky trade-off, again, between privacy and better services. Okay? When we look at cases, we always look at the worst scenarios. What is the negative story that could happen? And it is only if we think that the negative story may happen, but we begin to look at the positive side effects of the story that looks negative. When I talk about the data advantage scenario, for instance, it's all about a competitor being more efficient. Okay? So we have to, first we're wondering, will it become so efficient that it may drive out some rivals? And first we look at this side of the scenario, and afterwards we look at, wait, it may drive out some rivals, but it may also bring some more efficient products and so on. So we'll look at both sides. But very often, only one side is enough to make a conclusion about the case.
No, it's for me, just again, that's usage. This is really the topic. And it's nobody, and when you set up a platform and you say that perfectly, most of those platforms before, I used to work for eBay, I can tell you that it was impossible at one moment really to anticipate what would be the usage by the user of the platform. So we link to your point and to the point that probably user will be the key driver. I'm not able to explain why, in fact, my friend is going to Instagram and me, I'm still prefer Facebook or things like that. This is usage. And in fact, in technology, the majority of the time, and in particular, the way the trend is, I'm sure that will be probably one of the key driver to assess, usage of the platform.
Maybe one or two last questions.
Thank you. My understanding, but I'm not completely sure about what say the panel, is that, let's say, competition is policy, it's good enough with some few modification to deal with the digital issues. And regulation is not the solution. It's my understanding, but maybe I'm wrong. If it's that, if I understand, what do you think about the solution proposed by the Furman report,
So I agree. I want to say, and I'll just try to be clear about it. What I heard said here is that when we are working within antitrust, we have the right set of tools to do that. But that's what I tried to say. It's a category question, right? Maybe antitrust is not the right lens to be looking at these markets. And that's, I think, what the Furman report says. I mean, the Furman report, I think, says exactly what we just said, which is they like traditional antitrust, but, right? And the but is they say we need more pro-competitive tools. I had a slide, though I had 44 slides, so how could you remember them all, right? I had a slide in which I quoted from that report, and that report calls for, I'll call it data sharing as a tool for doing that. And so that is very much a kind of access regulation that we associate with regulated industries. And I think what I tried to suggest is I completely understand why you might think that's the right approach. I do not think that will be easy to do. That's not to say it's the wrong undertaking. We just ought to be prepared as to how hard that is. And I do think the Cambridge Analytica situation and the fact that Facebook set up this platform API and then the consequences associated with that, that's what we ought to be aware of. Now, I don't think Cambridge Analytica is a big deal. I just want to be clear. I just do not. So that doesn't scare me, but I don't know if that's the majority view.
Maybe one last question.
Thank you. Just one quick last question. We say that data is a non-rivalrous good, but yet under GDPR, when data is collected by a company to be processed, it can be processed only by this company. And how do you articulate that? Because this company cannot transfer the data to another one. It cannot be used for another purpose. So we kind of have a weird articulation between the fact that the data has to be processed only for one thing, for one purpose, and the fact that we assume that it can be reused by another company.
Yeah, probably just one kind of economic answer to your question. I mean, actually, it is welfare increasing to share non-rival goods. Okay, so but here we have an issue, which is privacy. Okay, so there is a trade-off between the fact that data is non-rival and could be shared, and the fact that everybody decides to share data will be probably welfare increasing, because this is kind of a big result from the economic theory. And on the other hand, we have this privacy issue, and I think. Well, I think this is one economic lecture of the regulation. Okay, the regulation has to deal with these two kind of opposite objectives. One, ensure welfare and ensure that you can share your data because this is welfare increasing, and the other one is, I don't know if it's consumer protection, and it's two different kinds of law. I mean, it's not my problem, if I may say. But the thing is, I clearly understand that we have two opposite objectives, and the regulation is trying to deal with these two opposite objectives.
Okay, well, let me say thank you very much to the four of you, and thank you to the audience. Thank you very much.